I'm Detective Adam Tateran from the Ottawa Police Service. I'm here to explain the process of testifying as a witness in a criminal court. This video was created to assist in preparing to provide testimony in criminal court matters. I am speaking as a detective who deals mostly with domestic violence offenses, but this information can be used for testimony in other criminal court matters as well. The City of Ottawa Courthouse is at 161 Elgin Street. There is parking in the basement with entrances from Elgin Street and Laurier Avenue. Parking can fill up and be difficult to get after 9 a.m., so the earlier you can get there, the better. The entrance to the court has security and a metal detector. There are items that will not be allowed in. This could include things that could be considered weapons, alcohol, substances, or substance paraphernalia. Think of it like going through airport security and consider choosing what you bring with you accordingly. It's recommended to arrive at the courtroom at least 30 to 45 minutes before the scheduled time. The offices for the Victim Witness Assistance Program, or VWAP, are on the 4th floor, right off the elevators. If you have an assigned VWAP worker that you have been in contact with, you should attend the 4th floor to meet with them there. If not, you can wait outside the assigned courtroom, which will be listed on the subpoena. It may be that the courtroom will change. It may also be that the matter does not proceed exactly at the time on the subpoena. This may be because of issues with staffing or resources at the courthouse. Be patient. The Crown, police officers, and VWAP workers will be keeping you up to date. It is out of their control. Typically, you will enter the court and sit directly next to a judge in the witness box. Officers and court staff will help you with where to go. Remember to be respectful of the judge and to stand and sit when you are told to by the court staff. Before you testify, you will be asked by a court clerk to either swear on a holy book or item or to affirm to tell the truth. The court will not consider one to have more or less importance than the other. The court will provide the book or item that you swear on, but it can be confirmed beforehand if there is one available. There typically will be an order that witnesses cannot remain in the courtroom itself. That may mean that if you have brought a person for support and that person is listed as a witness, they cannot stay in the courtroom during your testimony, and you cannot discuss your evidence with them. It's important that the evidence provided by witnesses be theirs alone, so witnesses cannot be exposed to the evidence of another witness. This would include discussion or sharing of evidence outside the courtroom. The accused will be in the courtroom. If there is a reason that you cannot testify in the same room as the accused, please make sure to tell the Crown. It's important to let the Crown know that if being in the same room would affect your ability to properly provide accurate testimony. An application can be made for specific reasons to have testimonial aids. These aids can include a privacy screen, a support animal, or testifying by CCTV. Please make sure to discuss any concerns you have in providing testimony with the police and the Crown during the trial preparation process. It's important to review the statement that you gave the police before testifying. As a part of the trial preparation, you should be provided with a copy of the written statement. This may come from the Crown, VWAP, or the police. If you provided a video statement, you should be given either a transcript or have a chance to review the video itself. The most important thing in your testimony is to tell the truth. You have sworn or affirmed to tell the truth, and it's important to be as honest and accurate as possible. When providing evidence, it is important to include the entire truth and not omit anything. Omissions can be seen as not being fully honest. There can be reasons why someone might omit something. Either they are ashamed or embarrassed to talk about it, or they think they will get themselves or someone else in trouble, or maybe some other reason. It's important to know that you are compelled to tell the truth, so the evidence you provide is not able to be used against you to lay criminal charges. A common topic witnesses will avoid discussing will be drug or alcohol use. It is important to be full, frank, and fair and include this information. If evidence is later provided that drugs or alcohol were involved, and you purposely held back that information, then the testimony provided could be seen as not being forthcoming and truthful. The same goes for anything else that could be omitted. It's important to be forthright about what happened if it included actions that you yourself took. As part of ensuring that you are providing honest testimony, if you do not know the answer to a question, do not try to fill in the blanks with what you don't know. If you don't know, don't guess. Just like omitting something, if you guess and you guess wrong, it could be seen as not being fully truthful. If you do not recall the specific answer to a question, but you know that you provided the answer in the statement you provided to police, you can ask the court to review the document for the purpose of refreshing your memory. The Crown will be asking you open-ended questions. For example, if you were talking about a car, they may ask you what color the car is, instead of asking you if a car was red. The Crown's questions have to be structured in such a way that you provide the information, rather than the Crown providing it to you to agree or disagree with. The defense is able to ask you more suggestive questions. Using the car example, the defense may suggest to you that the car was a certain color. It is important that you listen to the question that they ask, then answer truthfully. If they suggest that the car was red, and when you know it to be blue, you can disagree and say that the car was blue. As always, it is important for you to tell the truth. The defense may also put questions to you that something did not happen. They are not calling you dishonest, but for them to have certain legal defenses, they have to put their thesis to you to agree or disagree with. The Crown will then have the opportunity to ask you further questions to clarify any issues that came up from your cross-examination with the defense. It's important to know that the Crown, police, and other witnesses are prohibited from talking to you about evidence during this process. During your testimony, if the Crown, police, or other witnesses seem to avoid having interaction with you, it is not personal. It does not have anything to do with what you said. Rather, it may be that they want to ensure that there is no question that your testimony is yours alone and to avoid even the appearance of improper communication. There may be a time that you are asked to step out of the court so that the lawyers and judge can discuss something you said. When you return, you will be given instructions from the judge on how to proceed. It is important to know that this does not mean that you did or said anything wrong, but rather the parties were just discussing a point of law. It is important to know that you are not to discuss your testimony with other witnesses while the matter is before the court. There is a chance that you may be recalled to provide more testimony to clarify certain points. The evidence has to be from you alone, not from information you receive from other witnesses. Above all, the most important thing is to tell the truth. You're there to present the evidence of what you are a witness to. If you are sure of something, say that you are sure. If someone suggests something to you that you know to be incorrect, it's important that you say that it is not correct and explain what is true. The court will take breaks in both the morning and afternoon sittings and will take a lunch break. If there is a reason why you need to take a brief break during your testimony, please ask for it, as the judge will not know if you do not ask. There will be water provided to you in the witness box, but other food and drink cannot be brought to testify. If there is a medical need for something to come with you, please discuss it with the Crown prior to testifying. Testifying can be stressful. It may mean hours discussing a traumatic event. Try to sleep before attending. Try to have meals. There will be water available as you testify. If there is a support person that is available, consider bringing them. They can always wait outside during your testimony if you wish, and be there to support you during breaks. I hope that this has provided you a brief overview of the court testimony process. If you have any further questions, please reach out to your victim services worker, the lead officer on your file, or the Crown's office.